The Court of Appeal sitting in Nigeria's capital, Abuja, recently nullified the election of Senator Simon Mwatkom and Musa Aga of the People's Democratic Party on grounds of not being validly elected. The appellate court had gone on to order a fresh election for all the political parties that participated in the said election. The court placed a time frame of 90 days for the execution of its order on the elections. We're now being joined by John Chris, a lawyer and constitutional law lecturer at Plateau State Polytechnic, for a bit of focus on that development. It's great to have you on the program. A very warm welcome. I'm just going to get straight into it. As a lawyer and a constitutional law lecturer, I'd love to know what your initial reaction is to this judgment.
Yes, the initial reaction to this judgment is confusing. Even as a lawyer, you begin to wonder what kind of judgment is this? Looking at the fact that the Constitution has spelled out what it means for you to qualify for an election and what it means for you to be validly nominated. All the legislators from Plateau State were validly nominated by the National Office of the PDP. So there is no how you say they are not nominated. The moment you said the candidate of Plateau States are not nominated, it means every other candidate in PDP, including the presidential candidate and vice presidential candidate, are not nominated, because nomination is absolutely for the nomination is absolutely the national headquarters of the party that nominates candidate. You cannot disqualify candidate because you said they are not validly nominated. As far as we are concerned, these are pre-election issues that the courts actually does not have jurisdiction to even advocate or adjudicate on those issues. So the issue of nomination and qualification and nomination is strictly a pre-election matter. And then the Constitution in Section 285 has spelled out what clearly is the qualification for you to contest an election. As far as we are concerned, all the candidates of PDP were validly nominated based on the provision of the Constitution and the provision of the Electoral Act 2022 as amended. So there is no how you would say a candidate is not nominated, is not qualified because he was not validly nominated. So all the candidates in Plateau State were validly nominated. So there is what we call also in law the doctrine of stare decisis. Now, you are bound by the decision of the Superior Court. The Supreme Court has said the issue of nomination and sponsorship are pre-election matters. So you cannot disqualify a validly elected senator or House of Rep member because of the issue of nomination or sponsorship. These are issues that are pre-election issues that are to be raised at the Federal High Court as the Constitution has spelled out.
All right, I'm going to do my best to dig into the technicalities around this. Justice Alfreda Dawodu Williams said, and I quote, "To avoid anarchy, I agree with the appellants that the court must protect an order of another court." That being with reference to the Supreme Court order that the PDP had to get their house in order with regards to ensuring that a state congress was held to be able to nominate candidates. 12 LGAs are said to have not participated in this party congress. Given those details spelled out, go on.
The party in Plateau State obeyed that court order. We have judgment of the Federal High Court where a candidate that contested House of Assembly in Lantan North constituency approached the Federal High Court to say that PDP does not have has not obeyed that court order. The Federal High Court in Jos said PDP had obeyed that court order. In February, 11 February this year, the Court of Appeal of Plateau State Division also upheld that decision of the Federal High Court. So I don't know. Court of Appeal is court of coordinate jurisdiction, whether Court of Appeal anywhere. So there is no how you said the Court of Appeal in Jos has upheld the fact that PDP has obeyed the court judgment. The judgment we are talking about is a judgment, is a corona judgment, the judgment that was given in 2020, and it was obeyed. And INEC presented facts that they supervise a repeat Congress. In the petitions, all the parties, both the petitioners, they presented the fact that they all INEC had conducted a repeated Congress on the 25th of September 2001. And they all participated. And all the local government, the 207 federal wards in Plateau State participated in that repeat Congress. And all of that. It was the local government that had issued, the local government issues, the local government ESCOs. Only local government ESCOs that had issues that were said, no, because you had issues in court, stop. But all the 207 federal wards in Plateau State participated in that Congress. So there was obeyance of that court order. And the fact is before the court. The fact was before the tribunal. So the tribunal really, the Court of Appeal erred by saying that judgment was not obeyed, because there is fact from the Court of Appeal jurisdiction that the judgment was actually obeyed. And then there is no how. By the time you said PDP, after all, the sponsorship and nomination was done by the national headquarters of PDP. All the candidates, all the aspirants came to Abuja here and picked up their forms for nomination. And it is the national headquarters that submitted the list of their nominated candidates. So how can you say Plateau is different? Now, the moment you want to say Plateau is different, that means, as I said, all other candidates in PDP are not validly nominated, because nomination, PDP is one. PDP does not have two certificates. PDP has one certificate everywhere. So the certificate of PDP is just, Plateau State is just a chapter. And looking at what happened, it's PDP that sent, national headquarters that sent people to go and conduct the Congress that pick up the 3 ad hoc delegates. It is the national that also sent people to go and conduct the primaries. The state chapter has no role whatsoever in the conduct of primaries and then the delegates and the primaries of PDP. So it is purely the activities of the national headquarters of PDP. So there is no how you will come and say, okay, PDP candidates are disqualified because they were not properly nominated. The Constitution clearly spelled out what it means to qualify. And then by all standards, all the candidates of PDP have qualified to that court order. And they have respected the court order, and they have qualified to contest the election. So we don't know. We receive all those judgments that sack our National Assembly members with mixed feelings. We don't know. It is judgment that is bereft of law. There is no legal nexus in this judgment. There is no morality. There is no even fear of God in this judgment. We don't know where it's coming from. That's why a National Assembly member will come out and boast that, look, we are going to do this thing because we are going to Court of Appeal, because we know people in Court of Appeal. And then it turned out to be that what he predicted come to fusion. How can someone predict that he was going to win a judgment at the Court of Appeal, and he got? So it is based on an interest. It is based on what we refer to as wickedness or something, because we don't expect a validly nominated and candidate to just be disqualified like that.
Now, Mr. John Chris, one of the hot conversations we've been having throughout the day today, of course, because we've been having a number of judgments coming in from appeal courts concerning different areas in Nigeria. Who is at fault and what is at fault? Is it time for us to sit down and review the Electoral Act and the loopholes that may exist therein? Or is the interpretation what's causing us to have so many disagreements? I mean, 94% of all elections that took place this year have ended up in court. So who are we to fault? Are the politicians at fault here? Are they playing games with the system? Or is it the Electoral Act that we need to do a review of?
I think we don't have problem with the Electoral Act. Despite the fact that it's not a perfect document, I also believe that we need to improve the Electoral Act. As you can see, the court judgment are giving the Court of Appeal specifically are giving contradictory judgments. If you hear judgments that are coming from the same case in Borno State, where they allege that the candidate disobeyed the Supreme Court order. You understand? The Court of Appeal said, no, this is not where to get justice. You cannot allege that disobedience to court order is not a ground for qualification. It's not a ground to annul an election. And then, in another breath, the Court of Appeal is using disobedience to court order as a basis for disqualifying candidates. After all, if you check the qualification of candidates, the court order is not there at all. However, it is good to obey court judgment, but this judgment, as I rightly mentioned, has been obeyed. However, we have different judgments arising from Court of Appeal, and then I feel we need to harmonize. There should be conferences in every election cycle where election matters are going to be decided. There should be conferences of judges, and then you look at the basic issue. What the Constitution provided that the Court of Appeal should check in every election is what happened on the election day. That is the business of the tribunal. Whether there was valid election, whether there was corrupt practices, whether there was fraud and all that. But if you begin to dig down deep, the Electoral Act has given timeline within which to be able to come up with the Electoral Act has given timeline within which you can approach the court on your issues. So the Electoral Act is clear when it says you have, after any candidate that participated in any primaries, you have 14 days within which to file your pre-election matter. And even if you do not file within 14 days, it has become a statute bar. So Electoral Act is clear on that. So what we need to do is to be able to have conferences for judges, to be able to know what are the issues. Because what is rising even this tension and apprehension is the differences, the different judgments that are coming, the inconsistency in the decisions of the Court of Appeal. In this breath, another decision on the same fact, on the same issue. This judge is saying this thing, and another judge is saying this. So what we need to do is to be able to have the judges of the Court of Appeal have conference on the issues that are raised so that a unanimous position will be taken. And then there should be also decisions that have been taken, mostly by the Supreme Court. We urge that the Court of Appeal are bound. That is what we are taught in school, and that's why we are teaching our children the doctrine of stare decisis, whereby the inferior court, the lower court, is bound by the decision of the superior court. So whatever the situation is, for our judiciary to be consistent, it is always good to respect decisions. If the Supreme Court have decided that the issue of nomination and sponsorship are pre-election matter, you cannot smuggle qualification, you cannot raise qualification and now smuggle the issue of nomination and sponsorship as the basis of qualification. The qualification that the Constitution contemplates is a qualification that has to do with your age, whether you are a citizen of Nigeria, whether you are a member of a political party and nominated by the political party, and you mustn't have been bankrupt and all that, and you mustn't have been convicted for a period of time. So we cannot be inconsistent and then be relying on things that are pre-election matter and then give interested judgments, give interested outcome. Imagine somebody like the member representing Jos South and Jos East Federal Constituency. He won his election with overwhelming close to 100,000 votes or thereabout. And today, you are saying because he has internal issues that are not verified, internal issues that are pre-election matter, you are taking out his mandate. You are bringing someone that cannot even win councillorship from his ward and then replacing him. And then that applies to all the candidates, all the 7 legislators that we lost so far at the National Assembly. They overwhelmingly won their election, and you are removing them for no cost now.
Now, talking about overwhelmingly winning elections, very quickly before we go, Mr. John Chris, Senator Simon Mwadkom has said that this is just a temporary setback. Now, do you think that this judgment is going to harm his chances going forward, or do you think this is an opportunity to reaffirm a victory at the polls? What are your thoughts?
Yeah, my thought is
very briefly, please. We just have 1 minute.
Plateau North Senatorial District very well. You will know that if you conduct election 100 times over, the PDP will always win. It has been the stronghold of PDP. So I'm very, very optimistic. If you conduct election today, if Senator Simon Mwadkom, the minority leader of the Senate that we have been robbed of, if he contests, he will win over and over and over again. So we are waiting to hear the decision of INEC to see who are going to be on the ballot. However, the Court of Appeal order said all parties therein should go and contest, meaning that PDP can also file a candidate in that election. So we are sure that Senator Malcolm, is a temporary setback, not to him, to all our legislators that were removed. I'm assuring you, they will come back strong and they will regain their seats when opportunity avail itself in due course.
Thank you so much, John Chris, lawyer and constitutional law lecturer at Plateau State Polytechnic. Thank you for your time.